LS&S Employment Law Overview for Managers, Supervisors, and Directors, Part 2. This is a high-level overview for awareness. Should you encounter situations related to anything mentioned in this video, please contact the Human Resources Department. The intent of this video is for informational purposes only. In no way is this video intended for legal advice or guidance. LS&S Employment Law Overview, Part 2, will cover harassment, pregnancy discrimination, pregnancy disability, FMLA, U.S. Department of Health and Human Services, the DOL, and much, much more. An employer can be held legally responsible for the actions of its employees, or if the company engages or does not take the appropriate action when dealing with harassment issues. So what's the harm with a little water cooler banter and light teasing between cubicle mates? Something that starts out small, before you know it, the molehill has turned into a mountain, and what started out as harmless fun suddenly turns into a prank that embarrasses or hurts someone else's feelings. When the fun turns ugly, the resulting atmosphere can create an unfriendly work environment that leads to low employee morale and low productivity. Coaching and developing employees is crucial. No rude or insensitive comments should be tolerated, even if it falls short of illegal harassment. Management plays a crucial role in identifying harassment and investigating situations. Please refer to the Employee Policy Guide for more information. Some states have very specific guidelines, such as the state of California, in regards to harassment training. Employers with 50 or more employees, anyone that manages people, management must receive 2 hours of training every 2 years, along with receiving training within 6 months of assuming their positions. Some of the topics for your harassment training include the importance of diversity, anti-discrimination laws, sexual harassment defined, conduct to be avoided, internet and email harassment, other forms of harassment, unwelcome physical behaviors, unwelcome verbal behaviors, retaliation, reporting discrimination and harassment. The Pregnancy Discrimination Act, an amendment of Title VII, makes it illegal to discriminate against a woman because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. This is an example where both state and federal laws must be adhered to, along with additional state laws to protect the employee. This example is for the state of California. Women who qualify for PDL are eligible for up to 4 months of unpaid leave. An employer can hire a temporary staff person to fill in during someone's absence. As a company, we must allow the employee to return or assume their previous position or a position that has a similar pay and responsibilities. California Family Rights Act, also known as CFRA, an employee may take an unpaid leave for the birth of a child for the purposes of bonding, for placement of a child in the employee's family for adoption or foster care, for the serious health condition of the employee's child, parent, or spouse, and for the employee's own serious health condition. FMLA is a federal law requiring covered employers to provide employees job-protected and unpaid leave for qualified medical and family reasons. An employee can take up to 12 weeks during this type of leave. Please refer to the FMLA process located on the intranet under the Human Resources tab. Under the watch of the U.S. Department of Health and Human Services is HIPAA. HIPAA is the Federal Health Insurance Probability and Accountability Act of 1996. The primary goal of the law is to make it easier for people to keep health insurance, protect confidentiality and security of healthcare information, and to help the healthcare industry control administrative costs. The DOL, the Department of Labor, is responsible for occupational safety, wage and hour standards, unemployment insurance benefits, reemployment services, and some economic statistics. Many U.S. states also have such a department within their state. Under the watch of the DOL are the following agencies. The Wage and Hour Division is the agency that enforces the Fair Labor Standards Act. The DOL also has other agencies, such as OSHA, the Occupational Safety and Health Administration, and OWCP, Office of Workers' Compensation Programs. Over the watch of the DOL is USERRA, Uniform Services Employment and Reemployment Rights Act of 1994, along with the Office of Federal Contract Compliance Programs, also known as OFCCP. The FLSA establishes minimum wage, overtime pay, record-keeping, and youth employment standards affecting employees in the private sector and in the federal, state, and local governments. Most employees are entitled to overtime pay under the Fair Labor Standards Act. They are called non-exempt employees. Employers must pay them 1.5 times their regular rate of pay when they work more than 40 hours in a week. The Fair Labor Standards Act contains dozens of exemptions under which specific categories of employers and employees are exempted from overtime pay requirements. There are criteria that need to be met in order to be considered an exempt employee based off of FLSA regulation. Please refer to the Employee Policy Guide for more information. With the Occupational Safety and Health Act of 1970, Congress created the Occupational Safety and Health Administration, also known as OSHA, to assure safe and healthful working conditions for working men and women by setting and enforcing standards and providing training, outreach, education, and assistance. The Office of Workers' Compensation Programs administers 4 major disability compensation programs, which provide wage replacement benefits, medical treatment, vocational rehabilitation, and other benefits to certain workers or their dependents who experience work-related injury or occupational disease. USERRA is a federal law intended to ensure that a person who has served in the Armed Forces, Reserve, National Guard, or other uniformed services is not disadvantaged in their civilian careers. They are promptly reemployed in their civilian jobs upon the return from duty and are not discriminated against employment based on past, present, or future military service. The purpose of the Office of Federal Contracts Compliance Programs, also known as OFCCP, is to enforce for the benefit of job seekers and wage earners the contractual promise of affirmative action and equal opportunity required of those who do business with the federal government. What does the OFCCP enforce? Audits and enforce 2 contractual promises. Take a look. Additional resources are available on the internet at InsideLSNS.com. You can find information regarding leaves and absences, reasonable accommodation requests, IIPP safety plans, breaks and meal rest periods, and incident reporting. If you have any questions regarding this video or any HR questions, please feel free to contact Victor.Hernandez at lsslibraries.com or Maria Ariza at lsslibraries.com.